Fellow journalists, editors, friends, ladies and gentlemen. It's my privilege and honor to welcome you to the 11th B.G. Verghese Memorial Lecture. Many in this auditorium would know who B.G. Verghese was, but there's an entirely new generation of journalists also. For their benefit, I would like to recall the life of B.G. Verghese. B.G. Verghese was an editor extraordinaire and a staunch upholder of the freedom of the press. He started his career with the Times of India and later became editor of Hindustan Times and the Indian Express. A recipient of the Magsaysay Award in 1975, Verghese was uncompromising in his commitment to free speech and the citizen's right to know. He was information advisor to the Prime Minister from 1966 to 1969 and a Gandhi Peace Foundation Fellow. He had a keen and enduring interest in developmental reporting and the social transformation it can bring about. He wrote 1.5 books, and I'm not going to list all the books here. But just recall that he wrote something called Reorienting India, Rage, Reconciliation and Security, Waters of Hope, a seminal book on river water sharing, Northeast Resurgent, Ethnicity, Insurgency, Governance and Development. Still, the basic book you must read if you want to understand India's Northeast. First Draft, Witness to the Making of Modern India, and Post Haste, Quintessential India. He was also, as Shuma told you, one of the founders of the Media Foundation, is chairperson for many years, and remained its guiding light until his passing away in December 2014. The Media Foundation instituted the B.G. Verghese Memorial Lecture in 2015 in his memory. In the 11 years since its inception, the Memorial Lecture, which is supported by the Verghese family generously, and the India International Center, has been delivered by a number of eminent personalities such as former Governor Gopal Krishna Gandhi, Justice A.P. Shah, Justice Madan Lokur, former Vice President of India Hamid Ansari, former Union Minister for Environment Jairam Ramesh, and former Editor-in-Chief of The Guardian, Alan Rusbridger, among others. The B.G. Verghese Memorial Lecture 2024 last year was delivered by editor and author T.N. Nenan, on work and wages, old challenges in the age of automation and AI. This year's B.G. Verghese Memorial Lecture will be delivered by one of our most eminent jurists, Justice S. Muralidhar. Although he needs no introduction to people who have read newspapers because he was in the Delhi High Court for a long time and have read his judgments, but let me say a few words about him before inviting him to deliver the 11th B.G. Verghese Memorial Lecture. Justice Muralidhar is highly respected for his progressive judgments, both in the judiciary and in the public. Throughout his career, he has delivered landmark rulings on sensitive issues, such as decriminalizing homosexuality in the Naz Foundation case 2009, ensuring accountability in the 1984 anti-Sikh riots, and addressing hate speech during the 2020 Delhi riots. He began his law practice in Chennai in September 1984. In July 1987, he shifted his practice to Delhi. He practiced in the Supreme Court of India and the Delhi High Court for nearly 2 decades. During this time, he conducted several pro bono and PIL cases. He was active as a lawyer for the Supreme Court Legal Services Committee. Apart from being the counsel for the Election Commission of India and the National Human Rights Commission, he was a part-time member of the Law Commission of India from December 2002 till May 2006. He was appointed as a judge of the Delhi High Court on 29th May 2006 and became Chief Justice of the High Court of Orissa on 4th January 2021, retiring on 7th August 2023. As a judge, he has delivered judgments in every branch of law, including constitutional, commercial, arbitration, tax, and criminal laws. Many of his judgments have contributed to the development of law in that field. As Chief Justice of the High Court of Orissa, he spearheaded reforms on the administrative and judicial fronts in the High Court and the district courts, including the digitization of court records. Justice Muralidhar is an exceptional voice on the interplay between courts, media, and the freedom of the press due to his deep understanding of constitutional principles and his progressive judicial philosophy. Throughout his career, he has emphasized the importance of transparency and accountability in the judiciary and has even supported the disclosure of judges' assets under the Right to Information Act. His rulings and speeches reflect a commitment to upholding the fundamental right to freedom of speech and expression. This evening, we look forward to his insights into the evolving relationship between politics, judiciary, and the media in this year's B.G. Verghese Memorial Lecture. May I now invite Justice Muralidhar to the podium to deliver his lecture on media, courts, and freedom of expression. Justice Muralidhar.
Thank you, Bharatji. Good evening. Two disclosures. I'm not a robot, and this speech is not prepared by ChatGPT. It's indeed a deep honor to be asked to deliver a lecture in the memory of the journalist doyen, Shri Verghese. I think it's even more a pleasure to be there to celebrate young journalists in India today, where we're giving them awards in the names of three very courageous journalists, Chamili Deviji, Kamla Mankekarji, and Vishwanathji. I've divided up my speech into beginning with the prologue and then analyzing what we get from the prologue. In July 2024, Reporters Without Borders, and I'll use the acronym RSF because it's a French name, published its annual report on the World Press Freedom Index. Of the 180 countries surveyed, India's rank was 159 for 2024, which was an improvement by 2 ranks from the previous year, 2023. It is believed that this improvement in the rank was because some of the other countries had done so badly, their ranking had plummeted. This report is published annually by the RSF since 2002. It is based on certain parameters which does not include the quality of journalism or human rights violations in general. A country's performance is evaluated on 5 distinct categories: political context, legal framework, economic context, social cultural context, and safety. India's performance has been consistently wanting. Its WPF rank, which was 140 in 2019, sunk to 161 in 2023. Its score in 2024 was 31.28, placing it in the very severe category as far as deprivation of press freedom is concerned. Basically, bad news. But then even worldwide, as RSF noted, there was a discernible lack of political will to protect journalists. The RSF further pointed out that notwithstanding the UN Security Resolution 2222, which urges member states to create and maintain in law and in practice safe and enabling environment for journalists, and without undue interference in situations of armed conflict, the Israeli security forces have, since October 2023, when the conflict with Palestine commenced, they've killed more than 100 reporters and 22 in the course of their work. Here, in the monsoon session of Parliament, in July 2024, an opposition member of Parliament raised an unstart question whether the Union Information and Broadcasting Minister was aware of India's poor WPF index rank. Ashwini Vaishnav's response was disappointing. He began with discrediting the RSF, saying that it had evaluated press freedom using a very low sample size with little or no understanding of India and its vibrant democracy. According to him, RSF, as well as its methodology, were questionable and not reliable. Vaishnav proclaimed in Parliament that India has a robust and flourishing press. He cited the increase in registered newspapers from 2023 to 2024, an increase in the private satellite channels from 821 in 2023 to 919 in 2024. When I read what the INB minister had said, I got curious. Although his response was in keeping with the government's reaction to reports of other international bodies that paint an unflattering picture of our country, and here I mean the HDI report, the Social Progress Report, the World Hunger Report, I said I should give him the benefit of doubt. Maybe we do have a robust and flourishing press. Maybe the RSF got it all wrong. I picked up one of the parameters mentioned. Is there a barrier to the free flow of information on the internet? 5th August 2019, the date on which the Parliament abrogated Article 370, was acclaimed as a historic moment for our country. It was also the date from which a complete internet shutdown was ordered throughout the territories of Jammu and Kashmir and Ladakh, which became union territories. This, among many other things, meant that the press there could not effectively function. Anuradha Bhasin, the editor of Kashmir Times, a leading local newspaper, petitioned the Supreme Court of India in a writ petition questioning the legality of the measure. She was joined by others, including Ghulam Nabi Azad, a leading politician in the region. The question was whether the powers of the government under the Temporary Suspension of Telecom Services, Public Emergency or Public Service Rules 2017, I will refer to them as the suspension rules, notified under the Telegraph Act, were properly exercised, or whether they were, in terms of Subarticle 2, 19 Subarticle 2 of the Constitution, an unreasonable restriction on the freedom of the press under Article 19(1)(a) of the Constitution. Secondly, was the state obliged to place the orders of internet shutdown in the public domain, and were they amenable to judicial review? Thirdly, could there be a blanket order under Section 144 CRPC to ban gatherings anywhere throughout the territory of J&K and Ladakh? In what appeared at first blush to be a progressive judgment handed down on 10th January 2020 in Anuradha Bhasin versus Union of India, the Supreme Court answered the second set of questions in the affirmative. It recapitulated the settled legal position that the freedom of the press is a requirement in any democratic society, without which there cannot be transfer of information or requisite discussion. It held that the right to free speech and to carry on one's trade and profession on the internet were constitutionally protected under Articles 19(1)(a) and 19(1)(g) of the Constitution. The order under the suspension rules and under Section 144 CRPC were required to be made public and would be amenable to judicial review. So far, so good. The question whether the internet shutdown orders were disproportionate and had a chilling effect on the freedom of speech was left open, since the court was directing the review committee constituted under the suspension rules to conduct a periodic weekly review to examine the necessity to continue the restrictions. On the third aspect, the Supreme Court held that the power under Section 144 CRPC cannot be used to suppress legitimate expression of opinion or exercise of democratic rights, that such orders would be amenable to judicial review, and that repetitive orders under Section 144 CRPC would be an abuse of power and such. Thus, no real immediate relief was given to the petitioners. 4 months later, in May 2020, the Foundation for Media Professionals, FMP, again approached the Supreme Court, stating that none of its directions in Anuradha Bhasin had been obeyed by the government. This time, the court was lukewarm in its response. The list placed before it by the Solicitor General of the terrorist attacks that had taken place in J&K since 5th August 2019 seemed to weigh heavily with the court. It merely asked a review committee to examine whether the internet shutdown orders were required to be continued. No one was hauled up for contempt of court. Even 3 years later, when a fresh application was filed by FMP complaining of non-compliance, the court refused to entertain it. It appeared to be an instance of judicial abdication. The court was reluctant to implement its own orders. Internet shutdown orders are now almost routinely issued throughout the country. Farmers' protests, Manipur violence, and even during exams. These orders are not in the public domain and so remain inaccessible and unchallenged. India, Iran, Myanmar, and Ukraine are among the countries with the highest number of internet shutdowns in 2022 and 2023. According to an Access Now report, 2024 saw 294 internet shutdowns globally, and India accounted for 84 of them at 28%. Clearly, the RSF report cannot be dismissed as being unreliable or based on a questionable methodology. I next turn to the aspect of physical safety of journalists, a parameter highlighted in RSF's report. On 3rd May 2024, the World Press Freedom Day, the India Freedom of Expression Initiative, an alliance of press freedom NGOs, released the India Press Freedom Annual Report. The report pointed out that in 2023 alone, 5 journalists were killed. Of the 226 others targeted, 148 journalists were targeted by state actors and 78 by non-state actors that included politicians and criminals. Delhi reported the highest number targeted by state agencies, 51. 12 of these were women. The forms of targeting were arrests, detentions, registration of FIRs, being summoned for questioning, impounding of passports, raiding of dwelling places. 26 were physically attacked, threatened, or harassed by the police. Almost half of the 28 journalists killed in India since 2014 have been those covering environmental issues. They had invited the ire of the sand mining mafia and the criminal networks. 2024 has been no better. On 10th February 2024, Jyotiranjan Mahapatra, a reporter with the Bada Khabar TV in Odisha, was brutally attacked for his reporting, resulting in severe injuries to his head and hands. One day earlier, Nikhil Wagle's car was attacked by the ruling party workers while he was traveling in Pune to speak at a program. He had been critical of the Prime Minister and the former Deputy PM Advani after the latter was awarded the Bharat Ratna. Vinay Pandey, a journalist based in Nagpur, received on 31st May 2024 a beheading threat for reporting on the Gaza conflict. On 23rd May, Ankur Jaiswal was attacked by a politician and his cronies for publishing material that exposed their activities. Stopping journalists from traveling abroad at the last minute while they are set to board a plane has also been happening with regular frequency. While Rana Ayub could get the Delhi High Court to come to her rescue when she was set to travel to Europe to deliver talks on violence against women journalists, Sana Irshad Mattu, a Kashmiri photojournalist who won a Pulitzer Prize, was in October 2022 stopped at the Delhi airport despite having a valid US visa and prevented from receiving the prestigious award in New York. No reasons were given. Fahad Shah, Sajad Gul, Asif Sultan, Majid Haidari are some of the other Kashmiri journalists who have faced arrests under draconian criminal law provisions, including the Public Safety Act, and have been released after long periods of incarceration, sometimes in jails far away from Jammu and Kashmir. They were simply doing what any other journalist there would have been expected to do, reporting on the current situation. In Manipur too, senior journalists have been arrested. But then journalists elsewhere in the country who have been and are fearless in their reporting of events have been subject to arrests and secret surveillance by the state apparatus, as the Pegasus episode revealed. It is getting even more difficult to ignore the RSF report on India press freedom. The legal framework under which the media operates in this country includes the formal statutory body, the Press Council of India, headed by a former judge of the Supreme Court of India. The Press Council entertains complaints from the press against interference with its freedom by an authority, or complaints against the press by individuals for violation of the Code of Ethics. The Press Council exerts high moral authority, but is sadly, by and large, an ineffective oversight body. When its website prominently displays the PM's Pariksha Pe Charcha program, urging viewers to join the event and get unique tips from him, it raises eyebrows. The other body, which is a self-regulatory one for the electronic media, is the News Broadcasters and Digital Association, which has drawn up a code of ethics and broadcasting standards expected to be binding on its members, which are 27 news broadcasters, comprising 125 news and current affairs channels. Although it does adjudicate complaints and pass orders, these are often not complied with, making self-regulation a meaningless term. I now develop 3 themes. When I survey the terrain of courts and the media, 3 broad themes emerge. The first is that in order to be truly free and independent, the media in a democratic polity needs an independent judiciary. The second is, for an independent judiciary to remain effective in a democracy, it requires a free media. The third theme is that frequent use by the courts of the contempt jurisdiction has had a chilling effect on the freedom of the press. The first amendment to the Constitution sought to add restrictions on the freedom of speech under Article 19(1)(a) of the Constitution, which by then was recognized as including the freedom of the press. The amendment was triggered by 2 decisions handed down by the Supreme Court in 1950, the very first year of its functioning. The first in Ramesh Thapar lifted the ban imposed by the Madras government on Crossroads, a newspaper espousing communist causes and which was critical of Nehru's government. The ban cited danger to public order. The second decision in Brijbhushan Sharma struck down an order by the police commissioner here in Delhi under the East Punjab Public Safety Act, whereby the organizer, the mouthpiece of the RSS, would have to submit its issue in advance for a pre-publication censorship. Here too, public order was cited as the reason. With the Supreme Court having struck down both these orders, the consequential amendment to Article 19.2 in 1951 expressly introduced public order as an additional restriction on free speech. The Supreme Court has been consistent in upholding the freedom of the press in matters challenging government measures to control the price of newspapers, the levy of excessive customs duties on newsprint, or even issuing ejectment orders alleging violation of building bylaws or lease conditions. You will remember that the Indian Express building in Bahadur Shah Zafar Magh was the subject matter of a very famous case in 1985 in the Supreme Court, and the court struck down those ejectment orders. The Supreme Court clarified in the Cricket Association of Bengal case that the right to communicate included the right to communicate through any media that is available, whether print or electronic or audiovisual. I now come to a very important judgment which somehow has not been commented enough upon. In 2023, the Supreme Court set aside a Ministry of Information and Broadcasting order dated 31st January 2022, revoking the permission granted to Madhyam Broadcasting to uplink and downlink a news and current affairs channel, TV channel called Media One. The reason for revoking the permission was that the Intelligence Bureau had not given security clearance. When asked about this, the Solicitor General tendered to the Supreme Court the reasons in a sealed cover. The Supreme Court said it was not going to entertain such grounds for revoking a permission of a media channel in a sealed cover. It opened the sealed cover and in fact discussed the contents of the sealed cover in its judgment. One of the grounds on which the security clearance was denied was that Madhyam had been taking an anti-establishment stance. References were made in that report of the IB to Madhyam's reports on the UAPA, on the Armed Forces Special Powers Act, on development projects of the government, encounter killings, Citizenship Amendment Act, NRC, and the Indian judiciary's alleged double standards in terrorism cases. The second major ground for denying security clearance was that members or sympathizers of the Jamaat-e-Islami Hind had invested shares in Madhyam. Both these grounds were negatived by the Supreme Court, which reiterated that an independent press was vital for the robust functioning of a democratic republic. It said, and I quote, "The press has a duty to speak truth to power and present citizens with hard facts, enabling them to make choices that propel democracy in the right direction. Also, the critical views of Media One on the policies of the government could not be termed anti-establishment." This is what the Supreme Court said. The use of such a terminology in itself represented an expectation that the press must support the establishment. The denial of security clearance was viewed as producing a chilling effect on free speech, and in particular, on press freedom. The Supreme Court emphasized, criticism of government policy can by no stretch of imagination be brought within the fold of any of the grounds stipulated under Article 19.2. Separately, the Supreme Court found that there was no material to conclude that the investment by the Jamaat-e-Islami Hind sympathizers would affect India's security, or even to prove that Madhyam's shareholders were such sympathizers. The ministry was asked to renew the permission for uplinking and downloading of the Media One channel. And yet, when individual journalists who have been subjected to the criminal law processes have approached the Supreme Court, its response has been inconsistent. Some have received protection from arrest and bail in good time. Some have had to wait for long. Some have not been given any relief at all. A satirical comment in this context by a stand-up comic that some litigants were more privileged than others invited contempt of court proceedings being sanctioned against him by the then Attorney General. What seemed to have precipitated the move was the gentleman retweeting a cartoon that suggested executive dominance over the judiciary. In an era dominated by the social media, news first travels invariably from mobile phones to the electronic media and then to the print media. Maybe that order could have been reversed this morning. I'm not sure Bharat should know more about that. The morning newspaper is not how the day of the young Indian starts. It's the WhatsApp forward or the Facebook page. The last thing at night and the first thing in the morning. Anything that is more than a 3-minute read can wait. Only headlines, and within those, only the breaking news. The algorithm makes sure you read only what it thinks you wish to read. It tells you what to think and how. There is a spate of AI tools unleashed. Can you be sure that the journalist filing a report is not a machine, or that the report itself is not AI generated? We live in unsettling times. Two processes are working in tandem: robotizing humans and humanizing robots and machines that are learning at rapid speed. In this chain, at the first level, there are no real filters. The screening policies at Facebook, X, or YouTube are at best vague and unreliable. Social media then is fertile ground for disinformation, misinformation, and fake news. Since there is a rush to be first with the news, TV channels vie with each other to transmit whatever sensational news emerges from the tweets, Facebook, and Instagram pictures and messages without verifying its source or its veracity. If the TV channel is one that is aligned with the establishment, and these days they are in large numbers, there is next to no oversight and no consequences for the harm done. Hate speeches, spewing venom on TV is quite commonplace. The TV screen in Indian news channel is not merely noisy, it's chaotic cacophony where any attempt at rationality or truth-seeking gets buried deep. Even a die-hard cynic might be difficult to accept this as entertainment. But worse, there is a virtual news war out there on the net. The fact checkers have a tough time keeping track of fake news and dealing with the troll armies that deploy social media handles and bots, some of them created by the IT cells of political parties. This is a whole new game, a free-for-all where sanity is a scarce commodity. This is the age of influencers, both good and bad. The damage is done first, and since the internet does not forget, in an irreversible, substantial way. The 2025 Global Risks Report, brought out by the World Economic Forum, has said that for a second consecutive year, India is among those countries which are at a high risk of misinformation and disinformation. The report points out to the affinities between censorship and surveillance, societal polarization, misinformation and disinformation, and online harms, highlighting the confluence of these risks in the digital ecosystem. The reaction to this chaos is unfortunately not well thought through. Takedown orders, gag orders by the state and by the courts at all levels have become commonplace. Ironically, fact checkers who call out fake news are accused of spreading harm. And the establishment has no hesitation in invoking the draconian criminal law provisions against them. Investigative journalism is under threat of concerted attack through civil and criminal defamation proceedings in courts, some by the powerful corporates and politicians. These brave reporters are then scurrying between lawyers' offices and courts, seeking protection from arrest or bail, or defending SLAP suits. SLAP is an acronym for Strategic Litigation Against Public Participation. It would, however, be a mistake to argue that because of its potential for immense harm, social media should not be accorded the same degree of protection as free speech in electronic and print media. That would then be facilitating the stifling of genuine dissent and public critique of institutions by the state and powerful entities like the MNCs and large corporates. The Bombay High Court has rightly held as unconstitutional the government's attempt to statutorily empower itself to be the exclusive fact checker for matters relating to it. The issue awaits the final word in the Supreme Court. I then move to another major theme that has emerged from what law has developed in this country, that is, criticism of the government is not anti-national. The US Supreme Court in New York Times versus Sullivan reminded that criticism of the government and those in administration, even by factually inaccurate statements, would not be actionable unless made with malice. In the Derbyshire County Council case, the House of Lords held that if institutions of government were permitted to sue for libel, it would place too undesirable a fetter on the freedom of speech. This in principle has been adopted by our Supreme Court too, and yet it is not being followed in practice. 3 instances will suffice to make the point. In 2023, the BBC broadcast a documentary that examined the present PM's action during the Gujarat riots of 2002. The ministry immediately invoked the emergency provisions of the IT rules and ordered it to be taken off the air. Was it a mere coincidence that this was soon followed by income tax personnel conducting surveys of the BBC's offices in India? The official spokesperson of the ruling party held a press conference in which he railed against the BBC as the most corrupt, with a history of working with malice against India. He rechristened BBC as the Brushed Bakwas Corporation. The reason for the takedown order remains secretive till date. A petition questioning the government action is yet to be heard and decided in the Supreme Court. Another batch of petitions, now on the back burner, is the one concerning the use by the central government of Pegasus spyware to place under surveillance the mobile phones of politicians, journalists, and even judges. The committee set up by the Supreme Court, headed by a former Supreme Court judge, submitted a report more than 2 years ago. The committee said that the central government was refusing to cooperate. The report remains in a sealed cover in the Supreme Court. After a long gap, the Supreme Court has now agreed to hear this case in April this year. The third egregious instance is the government blocking the entire website of Ananda Vikatan, a renowned and popular Tamil magazine, only because it carried a cartoon showing the PM in shackles seated next to Trump during his recent visit to the US. This angered the BJP state unit president, on whose complaint the ministry acted with alacrity. The Madras High Court ordered lifting of the blockade, but unfortunately made it conditional upon Ananda Vikatan taking down the cartoon. This is totally contrary to the settled legal position that mere criticism of the government, even if ill-informed, is not anti-national. It cannot result in a chilling effect on free speech. The defense of this measure by the Additional Solicitor General in the Madras High Court made curious reading. He cited friendly relations with foreign states, a ground of restriction under Article 19(2). It is hard to imagine Trump looking at that cartoon in Ananda Vikatan and deciding to break off diplomatic ties with India. But then the reaction of the BJP spokesman in Tamil Nadu was stranger. He thought that the freedom of press did not extend to making fun of the country and its 140 crore people. This is my take. The nation wants to know why in the times now, in our republic, in India today, it is so hard to tolerate a healthy sense of humor, the ability to laugh at oneself or take a dig at the government. I move on to the next broad theme, that the courts need an independent media. On 12th January 2018, something extraordinary happened. A press conference was held by 4 of the senior-most judges of the Supreme Court, 4 senior-most after the Chief Justice of India. They went public on how the then CJI was acting arbitrarily in the matter of allocation of cases. The judges said that with the independence of the judiciary and the future of democracy at stake, they had no other choice but to communicate to the nation to please take care of this institution. When asked why now, the senior-most of the 4 is supposed to have said that they did not want any wise men to say 20 years later that Justice Chalameshwar, Ranjan Gogoi, Lokur, and Kurian sold their souls and did not take care of the interests of this illustrious institution. It is quite another matter that the next Chief Justice of India, who was part of those 4, and who saw much value then in both an independent and noisy journalists and judges, was only too eager to gag the media when presiding over a bench on a Saturday morning on 20th April 2019 to address threats to the independence of the judiciary. He used this occasion to discredit his lady staffer who accused him of sexual harassment. He appealed to the wisdom of the media not to report on it. The courts regularly use the media to carry their press releases on judiciary's achievements, the disposal of cases in Lok Adalats. Incoming and outgoing CJIs give interviews to a select few journalists. A few correspondents are favored by some of the chief CJIs and sometimes other judges with exclusive scoops about the institution's inner workings. Like this morning, everybody wants to know why is it that only one newspaper carried this news and not the others. Not infrequently, a garrulous judge holds forth from the dais, making gratuitous comments, wanting them to be relayed through the press. Post-COVID-19, with hybrid hearings and live streaming of court proceedings, judges are in the public eye even if the press isn't watching. Social media has exposed many more dimensions of the judiciary. When the PMO's social media handle shared the video clip of the PM doing Aarti at the Ganesh Puja at the CJI's residence, it naturally became viral. Video clips of comments made by judges, not just inside the courts but outside too, are available within a few minutes to an entire social media audience across continents. Judicial vanity, judicial peeve, judicial wit, judicial anger are all on full display. I now come to the next theme, which is about courts controlling the media. So what then of contempt of court? One senior lawyer termed the practice of the law of contempt in India as an instance of the paradox of the love-hate relationship between the press and the judiciary. They need each other, but the judiciary would like to tell the press where it gets off. Beer Biceps wasn't expecting that with the court protecting him from arrest, it would also admonish him to behave on his show. Thankfully, the court self-corrected. It is not unusual, though, for the court to tell a politician while granting him bail that he will not address meetings and so on. The Supreme Court does have a system of accreditation of journalists for the print and electronic media. But then in the age of live streaming, live tweeting, there are numerous news purveyors, not just journalists. In fact, if one visits the press room today in the Supreme Court, you will find journalists watching the monitor rather than jostle for space in a crowded courtroom to report on the happenings. The press has to watch out for contempt action in two contexts. One is interference with court proceedings, and the other is scandalizing the court through personal attacks on the motives of judges, as opposed to critiquing the institutional performance. In the first category, that is interference with court proceedings, the earliest instance was the media campaign run in 1961 by R.K. Karanjia's tabloid Blitz in support of Colonel Nanavati, who was being tried for the murder of his wife's paramour. It turned the jury in favor of Colonel Nanavati. This led to the disbanding of the jury system in India. The Sahara case, the Nupur Talwar case, and more recently the Riya Chakrabarti case, witnessed high-pitched shouting matches on TV screens of news channels, which were acting as prosecutor and judge. The guidelines framed in the Sahara case that an injunction could be granted where the reporting on a case might interfere with the right to a fair trial could be both overbroad and subjective. Judges in trial courts are vulnerable to intense public glare that the social media facilitates. It is necessary and prudent for judges at all levels to be cautious in engaging with the social media. Courts do cordon off trials from media, citing security reasons. Where the standards are vague, it is bound to have a chilling effect on the media, which then undermines the freedom of the press. The court has thankfully not yet placed restrictions on social media reporting on trials. After all, the criminal justice system is premised on public trials, and the press plays an important role in observing and reporting on the process. The second area where contempt proceedings could be attracted, the second area is of commenting on the court, its performance, its judgments, its judges. In the United States, the contempt power is rarely used by the courts against the press. In the United Kingdom, the Daily Mirror could get away with depicting the photos of 3 judges who granted an injunction in the Spycatcher case upside down with the screaming caption, "You fools." In November 2016, the Daily Mail, on its front page, depicted the photos of 3 of the judges of the UK Supreme Court with the caption, "Enemies of the people." That court had ruled that the UK government could not bypass Parliament to begin the Brexit process. Neither instance attracted any notice of contempt. Way back in 1978, in a somewhat similar vein, Justice Krishna Iyer postulated the Mulgaonkar principles to govern contempt proceedings. One of those was that the court will not be prompted to act as a result of easy irritability. Indeed, occasionally the Supreme Court has said that its shoulders are broad enough to shrug off ill-informed criticism. However, that is not quite how the judiciary as a whole has responded to public criticism. It has bristled with indignation. Arundhati Roy spent a day in Tihar jail for criticizing the court's muzzling of dissent over its judgment in the Narmada case. Patricia Mukim, the editor of Shillong Times, and her publisher were held guilty of contempt for suggesting that a judge had improperly acted in his own cause when, on the day of his retirement, he passed a judicial order directing the state to provide retired judges with a slew of benefits. Apart from sentencing them to stand in one corner of the courtroom till the end of the working hours, Malord slapped a fine of 2 lakhs, loudly stating that this would shut the newspaper. Thankfully, the Supreme Court stayed the order. Recently, when Wikipedia opened a page on its website to report on the case between ANI and itself in the Delhi High Court, it invited from the Delhi High Court a notice of contempt. In an appeal by Wikipedia, the Supreme Court is reported to have questioned why the High Court was being so touchy about court proceedings. I now come to the last part. These are my concluding thoughts. It is clear that when the INB minister described Indian press as robust and flourishing, he could not have meant free and independent. The media in India has had to fight for its independence and for its freedom. It is a fact, though, that much of the mainstream print and electronic media are either owned by large corporate houses or by political parties. Both print and electronic media operate on purely commercial lines, dependent as they are on government advertisements, licenses and permissions, corporate sponsorships, commercials. These very media houses also have their corresponding web versions. As Joseph Pulitzer cautioned, once a publisher comes to regard the press as exclusively a commercial business, there is an end of its moral power. Self-censorship, paid news, advertorials, large self-promoting ads of governments on several front pages, vying for greater TRPs at the risk of fudging data, are all now passé. There is also the control through sponsorship of the independent press on the net by corporate philanthropies. The big challenge then is to keep news free. Recently, I was sharing a panel with a senior lawyer who's also a member of parliament of the ruling party. The moderator asked us whether it was a matter of concern that much of the corporate-controlled mainstream media is aligned with the establishment. My fellow panelists' response was ingenious. They were exercising, he said, their free choice to align with the government. They could fearlessly report whatever the government told them. He was in plain denial that there was any muzzling of the press. For more than a decade now, the PM of the largest democracy in the world has not held a non-curated press conference to subject his government's performance to the scrutiny by the media, and yet there is but a whimper of protest. In his memoirs titled Hidden Agendas, veteran journalist John Pilger says that when Murdoch took over a newspaper, the reporters there would self-censor. They knew that some stories would never go past the editor's desk. Walter Lippmann warned that the threat to press freedom is not as much from pressures and intimidation that they face, but from those of their ilk that are readily co-opted into the heady mix of politics with the reward of proximity to the corridors of power. When asked to bend, they crawl. They might do well to heed Benjamin Franklin, who said, "They who would give up essential liberty to purchase a little temporary safety deserve neither liberty nor safety." While we find ourselves engulfed by WhatsApp forwards, which tend to hide the real news, not everything about the internet and social media is only troubling. It has provided space to journalists and influencers to speak fearlessly and carry their followers with them, free of control by state agencies. It has also provided such journalists with a two-way communication channel with a worldwide audience. And occasionally, tucked away in the corners of the print and electronic media, there is space yet for the investigative and critically analytical pieces of fearless and independent reporters, some of whom are being honored here today. Their courage and conviction will undoubtedly inspire generations of reporters. They need not just our admiration, but importantly, our support. They are our hope for a free and independent press, an impartial and trusted media in the India of the future. What is also encouraging is that they are not alone. Growing numbers of such independent scribes have formed global coalitions. The Panama Papers exposed a clandestine world of offshore finance and provided evidence of how heads of state, billionaires, celebrities, and business magnates used offshore structures to evade taxes, launder money, and conduct illicit activities away from public scrutiny. This was a result of a mammoth exercise undertaken by the International Consortium of Investigative Journalists, which brought together a diverse coalition of over 370 journalists from more than 100 media organizations across 76 countries to probe through 11.5 million documents. It tells us that even amidst threats and pressures, there will be those who are willing to risk their all to uncover and uphold the truth. As for the judiciary, it will have to develop the ability to receive criticism of its actions by the press, which performs the salutary function of holding it to account. Maybe the judges should recall what Lord Denning said in declining to proceed with a contempt case against Quentin Hogg. And this is what Denning said. Let me say at once that we will never use this jurisdiction as a means to uphold our own dignity. That must rest on surer foundations. Nor will we use it to suppress those who speak against us. We do not fear criticism, nor do we resent it. For there is something far more important at stake. It is no less than freedom of speech itself. It is the right of every man, in parliament or out of it, in the press or over the broadcast, to make fair comment, even outspoken comment, on matters of public interest. Thank you for your very patient listening. Thank you.
Thank you, Justice Muralidhar. I'm not going to even attempt to summarize what Justice Muralidhar has said. It was a masterclass on media, courts, and the freedom of expression. One of my wise editors once told me, never send an idiot to cover Einstein. He will bring Einstein down to his level and make a mess of it. So, heeding his advice, I will not attempt to summarize whatever Justice Muralidhar has said. I'm sure you're soaking it in your own wisdom. Only thing I want to say is that journalists of my age tend to say that our journalism used to be great and journalism's gone to the dogs now. Actually, that's not the case. Mainstream journalism may have gone to the dogs. Excellent journalism is still being done on the margins. And we need to show solidarity with those journalists and such journalistic ventures, as the judge suggested, and appreciate them. That's what we at the Media Foundation are trying to do. I will now close this part of the session, and you will see how we are trying to do this in the next part. Shuma, will you please take over? Thank you once again, Justice Muralidhar.